David to look through the participants on Zoom and can tell us that we're all here but 6. So,
good morning, everybody. The members who are present on Zoom are Chief Justice Nathan Hecht, Presiding Judge Sharon Keller, Mr. John Gimbel, Judge Bill Gravel, Judge Missy Mederi, Judge Emily Miskell, Judge Valencia Nash, Judge Kathleen Person, Ms. Rachel Rax, Chief Justice Sherry Raddick, Mr. Kenneth Sachs, Justice Maggie Sawyer, Judge Ed Spillane, Justice Ken Wise, Mr. Evan Young, and Senator Judith Saffarini. I don't think I missed anyone, but that's who all the members that are present, Chief, and you have a quorum.
Thank you. Welcome to everyone this morning, still on Zoom, but perhaps the next time we meet, we can meet in person. We're certainly trying. Just a reminder that the meeting is being webcast live and is also being recorded, and it will be available in archives later. 13 months into the pandemic, I hope we are kind of looking toward the back end now with vaccines. Through it all, the courts have continued to operate pretty well, and I'm proud of the work the judges have done here. I'm president of the Conference of Chief Justices, and so I get to see pretty much every day how courts are doing throughout the country. And Texas has really been a model in many respects, certainly in remote hearings, which we'll hear about today. And I think we can all be proud of the work that the Texas judiciary has done. And I thank you all for your participation in that. We've had about, our panelists can give us numbers a little later, but some 1.2 million remote hearings and 50 virtual jury trials, which is, that may be a national record. And then we're starting to come back with in-person jury trials. So we're beginning to move to whatever the new normal is going to look like, and the many challenges that lie ahead. And the council has a number of issues today and going forward that we'll have to contend with as time passes. But today, we want to learn more about the impact of the pandemic and remote proceedings on court dockets, and we'll get an update on our statistics for last year and also on the legislative session. 3 members who have retired from the bench and were appointed to the council as judicial members. Their terms have ended. They're District Judge Kelly Moore, who was also regional presiding judge for several years, has retired. Justice Bill Boyce on the Court of Appeals in Houston is back into private practice. Judge Moore was chair of our Criminal Justice Committee and did a lot of good work in that area. Justice Boyce was chair of the Mental Health Committee and the Strategic Vision Committee, both very important efforts on the council's behalf. And then County Court at Law Judge Vivian Torres has likewise retired. So we have 3 new members. One is Justice Ken Wise from the 14th Court of Appeals in Houston. He's been there since 2013 and has been a district judge, local administrative judge in the past. He is an adjunct professor at the University of Houston Law Center and hails from Texas A&M and the University of Houston Law Center, where he got his JD. Ken is something of a Texas history guru and sometimes sponsors a podcast, which you might want to check out when he does. Always very interesting. Second new member is District Judge Missy Maderi of Corpus Christi. Judge Maderi has been a district judge in Nueces County since 2011 and also a regional presiding judge since 2015. And I'll just pause here for a second and say, really among the heroes of the pandemic, of our transitioning through the pandemic, were the regional presiding judges. Their jobs were hardly as demanding before the pandemic as they have been during, and they have met sometimes twice a week when things were flying around pretty fast, trying to keep the judiciary throughout the state functioning. And I just am very grateful to the regional presiding judges for all the work that they have done. Missy was a prosecutor in New Orleans, as well as Harris County and Nueces County, and previously a municipal court judge. And she got her undergraduate degree at the University of Missouri at Columbia and her law degree at Cal Western. And then our third new member is County Court at Law Judge Claudia Laird of Conroe. She's been on the County Court at Law number 2 in Montgomery County since 2011. Also a local administrative judge down there. She was a prosecutor in Montgomery County, practiced law in, did trial work, both in civil, family, and criminal cases at Simonson and Associates. And she was a law clerk to Justice Devine when he was a district judge. So Judge Laird got her undergraduate degree at Texas A&M. Oh, I just now noticed got two new Aggies on here. I should have paid a little more attention to that, but she Aggie undergrad like Justice Wise, and has a joint MBA and JD from the University of Houston. And two members have been reappointed, Judge Valencia Nash of Dallas and Judge Ed Spillane of College Station. While he resides close to Texas A&M, Judge Spillane is I believe, a Harvard and Chicago graduate, so we don't have to include him in the group. You had an opportunity to see the minutes of the September 24th meeting. Are there any corrections or objections to approval? If not, they will be approved. And that brings us to our action items for today. We'll begin with the Indigent Defense Commission, Jeff Burkhart.
Thank you, Chief. Good morning. It's good to see you all. TIDC has been very busy. We have formula grant payments going out to almost all 254 counties right now. We're in the middle of our competitive improvement grant cycle. We've got about 16 counties looking at building a new public defender office in Texas, and several other counties looking for other grants for managed assigned counsel systems or something else. We're continuing to do policy and fiscal monitoring remotely. We're hoping to get back, as the Chief was saying, to in-person work. Hopefully in the next couple months, we're working toward that. At the legislature, TIDC has 10 bills, and almost all of those have gotten a committee hearing so far. None of the bills have gotten any opposition in committee. We're, of course, working on the TIDC budget. I want to thank Judge Keller and the Chief and David for all their support in the legislature for TIDC. So we're making some progress there. The next TIDC board meeting is June 17th at 10 a.m. And one last note, I guess, in terms of the legislature, we are, in terms of the push for additional funding, we are anticipating, much like the judiciary is, a spike in cases related to COVID-19. We do have a jury trial backlog, so we are hoping to get additional funding in the legislature to help to address that. And I think that's the update from TIDC. I'm happy to take any questions you might have.
Questions for Jeff? Thank you, Jeff.
Thank you, Judge.
We'll move to a presentation on remote proceedings during the pandemic. As I said, Texas judges have been at the forefront nationally of continuing to provide access to justice through remote proceedings. And whether setting standards for those proceedings or conducting the first virtual jury trial or giving the planet a moment of levity in the I'm Not a Cat video, as we just discussed, the judges here to present for us today have led the way. The Supreme Court of Texas has convened a working group chaired by Chief Justice Tracy Christopher of the 14th Court of Appeals to examine statutes and consider rules changes that will facilitate remote proceedings after the emergency expires. During the emergency, the Supreme Court has the statutory authority to adopt those and change those procedures itself. But we don't want to lose that once the emergency is lifted. We don't anticipate that that will be soon. The emergency that the governor declared for Hurricane Harvey is still in effect. But we do want to go ahead and try to, as I said, map out the new normal and make sure that our procedures evolve in ways consistent with our practice through the pandemic. There's also legislation introduced by Senator Zaffarini, which to some of the same effect, which has begun a dialogue among stakeholders about how remote proceedings can be best used in the judiciary going forward. And I'm sure the council will want to be part of that dialogue. But we have Judges Emily Miskell here from Collin County, Judge Antonio Ortega from Bexar County, Judge Karen Crump from Travis County, and Judge Roy Ferguson from Brewster County. And they will present to us on remote proceedings. Judges, please take it away.
I think Judge Arteaga was addressing our first point. Do you want to begin?
Certainly, I'd love to. Good morning, everybody. Thank you for the invitation. I'm Judge Antonia Arteaga from San Antonio, Texas, the 57th District Court. I actually provide a very short PowerPoint. If I can share my screen, David, if that's okay with you, or Judge.
You should be able to, Judge. Go ahead.
Thank you very much. Let me see. All right. Are you seeing the screen yet? Do you see my screen?
We're seeing your desktop, Judge.
Okay, let me get it up for you. Hold on. I'm going to stop share for a second. And actually, I'm going to do it off of my iPad. I wanted to have a plan B just in case. So I'm going to try again to share this screen. And I'm going to start the broadcast. Okay, so now you're seeing my screen. And I'm going to go ahead and go to the PowerPoint and just go ahead and run the PowerPoint.
We're seeing it now, Judge.
Okay, well, the only thing you missed is that the really pretty picture of the Bexar County Courthouse. So this is slide one, an overview. I like it when people get straight to the point, Chief Justice, and here's the overview, just a nugget. Remote proceedings can be and already have been used in almost every type of case and every type of proceeding in the following courts: my own civil district court, criminal district courts, juvenile district courts, and probate courts, also the county civil and criminal courts as well. Let's see. In our civil district courts, you know, we have a series of kind of motions that we have, motions for summary judgment that are voluminous, sometimes lengthy, sometimes have multiple attorneys, motions to compel discovery, ex parte TROs. We've also done voir dire and bench trials. We actually have a pilot program currently in Bexar County in person. We're doing one bench trial, and it's actually been a hybrid so that we could practice, we could develop best practices, but we're still using virtual even there. And so that is our pilot program. We've done termination cases that have been 2 weeks long. I've had over 100 exhibits, more than 6 litigants as well. Additionally, we are currently doing at least 2 virtual jury trials. I'm very proud of our Bexar County Judiciary. We began using Zoom over a year ago in March, initially just for our judges meetings, and now we do everything via Zoom. We have approximately, and I was just corrected on this, 13 trials as of today. One is going to go to verdict today in Bexar County, and I've already told you about our pilot program. When we were thinking about starting in person, we wanted to gauge the community, our legal community. So with the help of the San Antonio Bar Association and David Evans, our president currently, they developed this amazing survey where we had at least over 600 San Antonio attorneys respond to their opinions on whether or not we should stay virtual or we should go in person. Look at this graph. Everything except jury trials and voir dire, everybody wants to continue to do some form of virtual, whether it's presiding court, agreed settings, divorces, civil hearings, sentencing, etc. If you look, the green is all virtual. And if you look on the left-hand side, everyone wants to do virtual of some sort. However, it is important to note that an overwhelming majority of our Bexar County attorneys are voicing that they want to make certain that voir dire and jury trials remain in person. That is the spike yellow that you see there on the right. And again, this is wonderful feedback from our San Antonio Bar Association, thanks to David Evans and June Moynihan, who helped put this all together. I think it speaks volumes. The thing about it, though, is that although nobody wants to have or overwhelming majority want to have in person, so do I, that's my favorite, but none of them want to come back yet. All of them overwhelmingly say that they don't believe that we're ready yet. If you look at the numbers that we have here, and I'm going to get into more information about that survey in just a minute. I just wanted to touch on the criminal district courts. Judge Ron Rangel is doing a wonderful job with the help of, with the direction of Sid Harrell as well. They've done everything short of voir dire and jury trials. Everything, sentencing, even victim impact statements, all are being done virtually in our Bexar County criminal district courts as well. Our juvenile courts, this is very time sensitive, and with juvenile courts, they have the ability to have dockets virtually, lets them handle those time sensitive before the child is about to age out. They can do 5 times as many hearings in a day on their dockets virtually than they can in person, where they're limited to approximately 5 cases virtually. I know in Judge Valdez's court right now in Bexar County, she has a docket daily and is hearing multiple cases and pleas. From a probation officer standpoint, they can work virtually, and whereas they would come to court on any given day and wait hours and hours and hours. That's no longer true. They can continue working wherever it is, at home or satellite, get so much work done, and then when they're ready, they let them in out of the waiting room. Probation officers, the feedback I'm hearing is they love it. The students love it. Parents love it because that's weighing on their shoulders and they want to be sure that they get this taken care of. Initially, a year ago, there was some issues with being able to access them on phones. They were not savvy at that time. And there was a mistake that they could get virtually involved through their school devices, which is not true, because the majority of those school devices have a firewall. So they could not report into their probation officer or into court using the school devices. So the probation officers had to get creative, and that they did. The DAs love it. Every day in Judge Valdez's court, there are 4 district attorneys, and I don't know how they do it. I know that they do it. All 4 are linked to that one court, and all 4 coordinate amongst themselves in doing all of this work virtually. Also, attorney participation in detention hearings where attorney is not required. Usually if you have a parent, then you can decide whether that juvenile who's offended allegedly can go home or not. Now we have greater participation in those afternoon detention hearings because of Zoom. And the juvenile justice system, I think, is benefiting greatly from this. Child Protective Services Court, according to Judge Peter Sakai, is thriving under the virtual setting. Parents don't need to pay parking, bus fare, daycare arrangements are moot now, and they can also take care of their kids who are also virtually at home. The family drug court that we have special in San Antonio has greater compliance and increased accountability thanks to Zoom and all that OCA has done to help us. Probate courts. I was wondering about this because we know the juvenile, the young in our system might be easier to get along with virtual, but what about our senior citizens? They love it. According to Judge Vasquez, it's safer, not just because of their virus, but there's also no stares, no crowds. And these litigants, whether it's guardianships or whatever it might be, they are involved and they know how to do it. And when they don't, they have someone to help. According to Judge Vasquez in our probate court in San Antonio, 99% of them do it without any problems. And when they have that 1%, there's usually someone there that can help them. And may I just add, my own mother at 77 just got on Facebook and she's virtually in as well. Finally, we have specialty courts that are thriving as well. Increased enrollment in the services that Child Protective Services or other agencies can provide. Counseling has made such great strides because just like our juries and virtual jury trials, the kids involved in these counseling sessions feel a greater ability to open up. And I believe it's also because they're home where they're most comfortable, and that leads to greater success in counseling. The future, that's up to you, Chief Justice, and to the legislature. But overall, employees, litigants, and even attorneys want to continue remote access to justice in one way or another, whether that's entirely in most proceedings, except for jury trials, for some attorneys, or if it's a hybrid, it just depends. This is just a picture of my happy jurors. Let me just tell you, hands down, our Bexar County community, our jurors love it. We've never had greater attendance. They help us virtually and have helped us find better practices thanks to our Bexar County jurors. What's new? If we're going to go into jury trials, whether virtually or if we go in person, we know it's going to require more funding because we're looking at different models in San Antonio, and every one of them require that we have security outside the courthouse potentially. So that might be something, that might be another reason why we try to engage more people in the virtual jury trial process. But our survey doesn't lie, and overwhelmingly, the San Antonio attorneys have voiced that they would prefer not to do in person, although we've had really great success with those that we have done. And then I would like to see more interaction with schools, whatever the future is. I know that I, for one, hope that virtual hearings are here to stay. Thank you. And I'll stop share.
All right, I had the second point, and I know we've run over to 2 screens, so I don't know if Kelly or David, if you can spotlight me just to make sure I don't get lost on screen 2. So my topic is participation. And so I just wanted to say up front, judges, we're not rabid early adopters of technology. We're stubborn and we're hard to change. And I and probably everyone else expected that we'd resentfully do virtual court and then hate it and quickly return to our old ways. But what I've seen now that I have a year's worth of experience under my belt has actually, converted me to a new way of thinking, as well as most of the judges that I've talked to. So obviously in the beginning, the number one concern we heard from everybody was that we were concerned about the most vulnerable in our community and the people who lack technology. And everybody wanted to make sure that we are not excluding those folks if we're doing court remotely. So now that I've done over 250 trials on Zoom, as well as countless other motions and hearings, actually what I have observed has been vastly increased participation from the folks that we would consider the most vulnerable in our community. It has really showed me how our traditional in-person court system has excluded a lot of people who need access to justice. So I'm just going to go through several different case types and how we have seen increased participation when we are able to offer the remote hearing option. My court primarily focuses on family law cases. As you'll see in the statistical report that's in our materials, family law cases make up about half of all civil cases that are filed in district and county courts. So I think it's a good amount of the public that we are dealing with. So first of all, self-represented litigants. And on my docket, I would guess that a majority of the people that I see are self-represented and do not have lawyers. Typically, when they come to court, they haven't filed any motions pre-trial. The only time we see them is when they show up on their trial date. They typically don't work with a lot of evidence because most evidence is on their smartphone. And so they will want to use a text message with a witness or enter in an audio recording into evidence, but they don't have it in a format that they can hand to the court reporter. And so that evidence just gets excluded. Now that those folks are allowed to participate remotely, how we are solving some of our evidence issues is we're requiring people to email their exhibits and exchange them and provide them to the court reporter the day before the hearing. And now my pro ses are using exhibits. They are introducing video recordings, text messages, emails. I mean, I'm seeing a ton more evidence from my self-represented litigants, which is a good thing because I want to make decisions that are based on relevant evidence. So I've been very impressed at our self-represented litigants being able to use evidence now that they're not structurally prevented from doing so. Secondly, they're showing up a lot more, period. We have fewer default judgments. One of the ways I've seen that especially is for dads. Sometimes dads may be in different states or they may have jobs. Like we've done trials where the dads have been long haul truckers and they have pulled over at a truck stop and participated in their child custody hearing through their smartphone. And to a traditional person who values the formality of the courtroom, that may sound horrifying. But to me, I look at it as that's a dad who's now included in decisions about their childhood or their child. And what the data shows us is that when dads have court orders for support and visitation, they stay involved with those children's lives early and often. So it is a good thing to have litigants there and have them not be default judgments. Number one, because I'm making decisions on better evidence when everyone's there. But number two, just the long-term effects of that on our communities. CPS cases. This was a case where we were very concerned about their access to justice because by far most of the parents I have in child welfare cases where the government is removing children from their families, the bulk of the parents in those cases are indigent. And so we would be the most concerned that they, for example, lack good Wi-Fi or a device that would let them participate. And what I found instead was that the in-person court excluded them because they lacked technology. Most of them don't have reliable working automobiles, and Collin County does not have public transportation to our courthouse. So frequently in the past, I just wouldn't see those parents in child welfare cases. And again, we want them there because we want them to participate. We want to return their children to them. We want them to be good parents. But if they are excluded because they can't get off work, they don't have a car, can't get to the courthouse, then they miss a huge part of this very important process. Now that we are doing all of our child welfare cases on Zoom, the parents attend basically every hearing, the ones that want to be involved, but they are not excluded from technology because most everyone does have access to a smartphone. Occasionally they have to dial in by telephone, but I would say, 90+% of the time they are appearing by video because they have access to a smartphone where they lacked access to the technology of a car. In addition, the legislature has always been concerned, or has recently been concerned, that we are not including foster placements enough in our child welfare hearings. And so they amended the family code, I believe in 2019, to require that we give notice to foster parents and that we allow foster parents an opportunity to speak in our child welfare hearings. But previous to the pandemic, I don't know that I ever saw a foster parent come to court in person because they have to find childcare for their other children. They have to transport themselves to the courthouse. It was just a big barrier. Now that we're doing child welfare hearings online, those foster parents are there almost every time. Also, grandparents, potential placements who may live out of state are able to participate on Zoom and be part of the process. Lastly, one of the points I wanted to emphasize for participation, this was something that didn't occur to me up front, but lately I've started to appreciate. Online is safer physically for a lot of people. A big portion of my docket is protective orders for family violence and for stalking. And I didn't realize it, but my protective order applicants have expressed what a relief it is that they feel like they are safe, that they are not coming physically in person to the courthouse where their stalker is waiting for them. And in person, we can do things like have a bailiff walk them to their car, but they just feel so much safer not being in person with the person who's accused of, committing violence or stalking on them. And so I think there's a place to consider the safety of the litigants as well going forward. I think that it would be absolutely easiest for me to return to 100% in person, because as you can tell from my virtual background, in-person courts are set up for my convenience. Right? It would absolutely be the easiest thing of all for me to say, as soon as I'm allowed to, no more virtual, we'll go back 100% in person. Makes my life a ton easier. I don't have to troubleshoot anyone's audio connection. But what I have seen so far, I have been blown away by how many vulnerable people that just apparently were not getting served by our legal community. And those people are showing up, participating in their trials, using evidence, and accessing justice like we want them to. So just the impact to that is just indescribable to me. And so that's why it's worth it to me to go forward with, how do I set a docket with some things in person and some things on Zoom? I'll figure it out. How can I accommodate the technology? We'll figure it out. But just, it's not a gimmick. I'm convinced it's here to stay. And then on results, sometimes when you talk to attorneys, you'll hear, well, we just all have to come back in person. Well, now that we're, in the process of opening back up into in-person, Wednesdays every week are in person in my court. If you want to come in person, you can, and just set your case on a Wednesday. And I'll just tell you, based on results, my Wednesdays don't fill up as fast as my Zoom days. So even though the attorneys are all saying they want to come back in person, or maybe that's just what they say to my face, based on results, they're not actually setting their cases on in-person days. So I'll stop there, but thank you so much for your attention to this topic.
Thank you. Good morning, Chief Justice Heck, Judge Keller, and council members. I'm Judge Karen Crump from the 250th District Court of Travis County. It is a pleasure to be here before you all to provide a brief report on remote jury trials in the state of Texas. Thanks to the foresight of the Office of Court Administration and our Texas Supreme Court, particularly David Slayton and his great team over at the OCA, Texas judges were not only prepared for remote hearings, but also with a lot of time and effort to conduct remote jury trials. To provide you a little bit of background, before the pandemic, Texas judges were trying 10,000 jury trials a year. The pandemic, which provided a real and specific risk to jurors, litigants, lawyers, and court staff, caused the jury trials in the state of Texas to come to a screeching halt. And really looking at the numbers in fiscal year 2020, from March 2020 to March 2021, compared to the 10,000 that we did before the pandemic, we had only tried 391 throughout the entire state. So the Texas Supreme Court, I know, in an effort to try to address that concern and to ensure that people had their constitutional right to a jury trial, created emergency orders, which allowed us, effective October 1st, 2020, to conduct remote jury trials, even over the objection of litigants, if a couple of conditions had been met. And one was that they not be on a jailable offense, and if the litigants had an opportunity to object to that platform at least 7 days before the jury trial, and to ensure that all jurors had access to technology, among other requirements, and it has worked. As Chief Justice Heck mentioned, Texas judges have completed, to a verdict, almost 50 all virtual jury trials. And in addition to that, we have conducted over 50 grand jury selections. We have prepared and published remote jury trial procedures and educated lawyers and litigants throughout the state on how to do this. It is without a doubt the most difficult and complicated way that we have had to do jury trials. As Judge Miskell mentioned, we'd all rather be in person. It is certainly more convenient. But for those who have to try cases before us, this provides a means to address the constitutional right to a jury trial and to keep all of our litigants, jurors, court staff, lawyers, and everyone safe during this pandemic. I personally have presided over 4 all virtual jury trials, including 2 CPS child welfare cases, 1 personal injury case, and one commercial property dispute to verdict. And the parties, the lawyers, the jurors, the litigants have provided overwhelming positive feedback. You might find it interesting that despite concerns about low juror turnout on a virtual platform, we have had a phenomenal juror show up rate. In 3 out of the 4 panels that I've called, every single one of our 55 jurors on the panel appeared, not only logged in, but logged in on time, and we were able to check in those jurors in a timely and efficient fashion. And the jurors who do show up, these are some of the most diverse juries we have seen in the time that I've been serving as a trial judge. The juries without transportation concerns or risk of illness show up, and they are very proud and happy to do their civic duty. More importantly, perhaps we have been able to ensure that litigants have their constitutional right to a jury met during this pandemic, and we're ensuring that there is access to justice and ensuring that there is due process for those who appear before us virtually. So even in those cases that aren't actually tried, the litigants have a court date. And that in and of itself causes litigants to communicate and to resolve their disputes. Once you have a jury trial setting, you're more likely to settle. And that has allowed us to break that backlog that was previously discussed and to actually get cases resolved. And that keeps the wheels of justice moving. So with that, I'm going to turn it over to my colleague over in West Texas, Judge Ferguson, and I welcome any questions that you may have at the end of our presentation. Thank you.
Thank you very much, Judge. And thank you, Chief Justice, for inviting us to address the group today, David, for your part in that as well. First, let me get this right out of the way. It's a very interesting group of judges that you've assembled to talk to you today, because we really cover the gamut of what kind of courts there are in the state. You've got San Antonio, which I think of as the big city. I know it's not Houston or Dallas, but to Marfa, it's enormous. And so you've got us working all the way down, and I'm here representing the rural counties, which is the majority of counties, but not the majority of people. And my experience with everything Judge Miskell said and everything Judge Crump said is exactly the same. And that's astonishing to think of the differences between my area and the lawyers who serve our area and the communities who are 2.5 hours from the courthouse in some of my counties. To the cities where they can just hop in the car and drive the highway. So these are consistencies across all communities in the state. I have been asked to open the conversation about our thoughts about how courts can or should use virtual proceedings going forward. And there are some things that we have to watch out for. And I know Senator Zaffarini and David have heard these things a ton. We have heard them, the presenters today, because we're on that remote proceedings task force. And so we have opened our ears to other lawyers and groups who want to share with us their thoughts about post-pandemic. And one thing that I've learned is you have to filter to some extent people telling you what other groups want or don't want. For example, in the criminal context, I'm a court of general jurisdiction, so I've held every kind of hearing except a criminal jury trial during the pandemic through Zoom. The Prosecutors Association tells me that it's the defense lawyers who don't want virtual hearings going forward. And the defense, but they do. And the Defense Association tells me that it's the prosecutors who are going to interfere with remote proceedings going forward, but they want them. And we hear similar things from other competing groups as well. And so what that led me to do was decide to do my own informal anonymous poll. And so I put out a Google poll to every lawyer who has appeared in the last year in the 394th or one of those 5 counties. It was all done online. I have no idea who responded, but I can tell you this. I don't have 60 lawyers who live in my 5 counties. I have about 15. So the majority of responding lawyers to this poll are polled from outside areas of all sizes. I have everything from Fort Stockton all the way up to Houston and Dallas lawyers who were polled and have responded to this. I asked them to respond based on their experiences with remote proceedings. I didn't want people who've never done one jumping in and poisoning the pool. I want people who have experience appearing before us and representing their clients to a decision. We got 58 responses, which sounds tiny to the city folk. Out here where we are, that's an enormous response for any kind of a bar poll or request. So let's walk through them just a little bit here. I have heard every single time I talk that lawyers want to eliminate remote proceedings and get back to in-person. I heard it yesterday when I spoke to a BOTA from a federal judge. That's not true, folks. When you ask them anonymously, do you want to have remote proceedings after the pandemic is over? Not now, but post-pandemic. 98.3% said yes. So don't be fooled by the generalizations that lawyers want to go back to the courthouse and turn the clock back 2 years. It is simply not true. They know better. 79.3% feel that remote hearings generally result in as high quality justice as in-person hearings. That number's higher than I expected. Now these are lawyers that we've asked, which means 50% of lawyers have lost some remote hearings, right? You can't win them all. And yet, almost 80% say that the quality of justice is just as good as in person. The level of technological competence, if you boil this down, 96.6% of lawyers polled feel they are technologically competent to participate in remote hearings. Now, in the rural areas, that's a bit of a surprise to me as well, because we don't have high dollar law firms out here. Almost everyone is a solo. And so to see 96.6% say they're competent to represent their clients well remotely was a telling response. Next, do you feel that outcomes would have been different if your proceedings had been held in person? I held my breath when I asked this question to the lawyers. The response was that 94.8% said rarely or never would the outcome have been different if they had been in person. 94.8%. Only 5.2% said often, and none said always. Y'all know lawyers like I do. I find this a surprising admission by the bar. Do you feel that the use of post-pandemic remote proceedings will improve or impede access to justice? 86.2% said improved. I was puzzled about the 14% who said it would impede. I think what I'm hearing is that those responses have to do with the ability for people to put on evidence. So I think they feel like, as Judge Miskell mentioned, they incorrectly feel that self-represented litigants would not get the same quality of justice. They don't get the same access to justice because they don't know how to do it remotely. Our experience after 1.2 million hearings is that has simply not been proved out. The opposite has been proved true. But there is a significant percentage, 14%, who are concerned about access to justice. All right, this one looks a little scattered, but it's actually not. That 65.5% of lawyers polled believe that courts should have the discretion to require remote hearings unless a party can show good cause as to why a hearing should be in person. What we learned in this poll is we were told that lawyers would oppose post-pandemic virtual hearings unless they had the decision. do we decide whether it's in person or remote? And what we were told they wanted was in person unless they agreed to remote. And the fact is the majority, and a relatively strong majority, feel the opposite is true. That's not the way they want this to happen. They want hearings remotely unless either the parties agree that it should be in person or the court finds good cause to do an in-person hearing. They want the default to be remote, ladies and gentlemen. That is the opposite of what we are hearing. All right, this one I also found to be interesting. With in-person proceedings, so if the court holds a post-pandemic in-person proceeding and someone objects to having to come in person, and we all know this is going to happen. We have people who they're highly vulnerable. Maybe they can't take the vaccine for a medical reason, or they're just very concerned. And they want to say, I want to appear remotely. It's almost 50-50 as to whether courts should allow them to appear hybrid in an in-person proceeding, or whether the court should force them to come in person. All right, there's a lot of information on this one, but I want to explain basically what it is. I asked two questions. For which of these types of proceedings, and I listed every one I could think of, do you feel they are usually better held on Zoom, or do you feel that they're rarely better held on Zoom? Usually better in person. The responses are exactly what the other judges have told you. The only things where a majority of lawyers said they're rarely better remotely were jury trials. Now, I will tell you that the lawyers who had done virtual jury trials are not included in that 74, 67, 65%. They all like the idea and say they're better doing them remotely in our rural areas. But the lawyers who had never done them strongly felt that it was a bad idea. Almost every other kind of hearing, a majority of lawyers said they're better off being remote. And I was a little surprised. Now, there were some things you won't see here. For example, bench trials are not on either list. And that's because I didn't get a majority either way. There might be 20% that said better on Zoom and 20% that said better in person. And so those don't appear. These are just the ones where we had a majority. But as you can see, when it comes to non-evidentiary hearings, when it comes to all criminal pretrial hearings, that should give you a moment for pause. Because remember, we've been told by both sides, the state and the defense, that the other side will object and not allow in-person proceedings for arraignments, motions hearings, pleas. All of those appear here with the majority of lawyers saying, yes, they're better remotely. So there's a lot of finger pointing, but when you ask them one-on-one, they tell you, I want it remote. It's just everyone else that doesn't. So a lot of the pushback we're getting is not real pushback, it is rumored pushback. And so we have gone and talked to a lot of these groups and a lot of these lawyers and asked them, if you could do it, what would you tell us you want to see? And I can tell you that the theme is relatively consistent. Here is what I have heard from pretty much every group, and this is not me advocating for this, this is me reporting to you. Non-evidentiary hearings, the vast majority want those to be on Zoom or remote, unless the court finds some really compelling reason to do it in person. With evidentiary preliminary hearings, they're happy to have them be presumed remote, but they want us to listen to them when they object to that and say we would rather have an evidentiary hearing in person. And that is the consistent theme I heard. It's not that they want to decide. It's not that they want veto power or agreement power, because we all know that that could lead to some abuse, to some suppression issues. That's not what they tell me they really want. What they really want is to be heard, because they know their case and we don't. They know the witnesses and the evidence, And we don't until we hear it. And so they really don't want to be excluded from that. They want a strong right to come in and object and try to show good cause for why it should be removed from remote and put in person. And then they want that decision with the court. One of those slides I showed you differentiated between those two. Do you want to have to agree, or do you want the court to be able to overrule? And the majority, the larger segment, said, we want the court to decide. We don't want the lawyers to be able to veto, which again, Senator Zaffarini will know that differs a little bit from what we had heard as we were talking to some of these groups. Without question, they want the right to tell us whether it's better in person or remote for a jury trial. And that's their number one thing. If you take that off the table, everyone could come to agreement, I think, in half an hour, because I've watched it happen with opposing groups. When jury trial is on the table and the question is, do we force it on them or not? Everybody digs in, and that becomes the center of the argument. I want to address one last very quick thing because it's happening right now. There's been a question, and I heard it in the Judiciary Committee meeting on the floor that was broadcast. I think Judge Miskell and David Slayton were testifying there. And one of the things I heard mentioned from the committee was, we're going to see a negative impact on participation and diversity due to this massive digital divide. And I will tell you that where this is Presidio County. This is one of the highest poverty rate counties in the state. It's on the border. It's bilingual. In fact, I think we have as many or more Spanish speakers than we have English speakers here. I have been doing jury trials there for 8 years. And traditionally, our jury response is between 13%. I'd say normally it's around 20-ish%, and the highest we would get is 30%. Right now, I have a virtual jury that's getting ready to start, and people log in online through our court's website. In the time that I have been talking, I have had 6 people log in and do their check-in. Rather than showing up for court dates, 6 people have logged in and filled out their questionnaire for qualifications and exemptions. So I am now over 60% response rate in Presidio County for this civil jury trial. That is historic. We've never been close to 50% before. I'm not sure we've ever hit 40%. And we're already at 60, and I'm not even closed yet. So we are seeing massive turnouts. I've done 5 virtual grand juries. And for the first time, I'm confident in saying that those grand juries demographically actually look like the community, because normally they don't. Certain segments of the population show up and certain ones don't. And right now, I'm getting a true cross-section of the communities because we did those grand juries online. It is a revolution in participation in the justice system in our communities. And before you say, but what about the people that don't have internet? We take care of them, because normally they would have to get in a car and drive to the courthouse. And so what we do now is, instead of everyone having to do that, I have a tablet set up in each building in our giant counties. So I have one in Marfa and I have one in Presidio in an annex. And anyone who calls the number on the card and says, well, I don't have any kind of an internet device, that person drives to the courthouse. They use my tablet and they do their check-in. And then we give them the device they need when they leave so that they can participate the morning of trial. So there's no divide for us, because everyone used to have to drive, and now only the people who don't have a device have to drive, and then we give them one, thanks to David Slayton and the Office of Court Administration and their wonderful program. So I want to now invite the other 3 panelists to jump in on this topic as far as the future, not the bills that are offered and not the nitty gritty, but what do we think the future should look like? Judge Crump.
And if I may, yeah, Judge Crump may have to sign off. Go ahead, Judge Crump.
I do need to sign off. I just wanted to say thank you all so much for your time, for the invitation, and for your support of the judiciary throughout the past year. It has been essential and appreciated. So I do need to jump to another call, and I thank you very much. Take care, all of you.
Thank you, Judge.
Thank you.
Thanks for being here.
I think we wanted to make sure we answered questions as well.
Yeah, let's see if there are questions. We just have a few minutes before we need to move on. This has been a great presentation. Facts are always more interesting than all the opinions that we get. So it's very good to have facts to look at. Questions of the judges?
Judge Person has her hand up.
Did you say Judge Person?
No?
Yeah, Judge Person has her hand up.
Judge Person,
Judge.
did you have a question?
More of just an echo, but also municipal courts. People who drive through my community are veterans, people seeking medical attention, soldiers have been absolutely relieved that just to get information, they don't have to drive in. And I have folks who treat for PTSD, et cetera. Code enforcement cases, again, we're getting better responses because people who are bedridden who didn't clean up can get a way to log in or phone in and talk to us about what's going on. And students are missing less school on our juvenile dockets, those first offender young people missing less school. So we're getting an overwhelming thumbs up from our communities. And I didn't hear us in the mix, but I wanted to go ahead and just plug that in. Most of the municipal court judges that I talk to and the people in my community are so relieved to have this option. And as far as folks who don't have technology, of course, we do have a walk-in docket available on a couple of different setting times that people can do that. But even folks who just can phone in, senior citizens, for example, who might not have the technology savvy, a lot of times can get enough information to figure out what they want to do to resolve their case effectively. We have a good rate. So I just wanted to add in, and I always will, the municipal court section, not to take too much time, but I think that you'll find our rates are echo what Judge Miskell, Judge Ferguson, and Judge Crump also relayed to you. Thank you.
Thanks, Judge. Anybody else?
Chief, there's one thing I'd like to respond to about that. Judge Person's exactly right. But interestingly, we have so much data from these 1.2 million hearings that we know how people are typically logging in. And one of the arguments we've had is, well, when someone calls in, you don't get as good of an appearance. Now, the US Supreme Court has their lawyers calling in, so that's a tough argument to make. But I agree that we need to see people. Less than 2% of participants in our 1.2, 1.3 million hearings are phoning in. The rest of them are appearing visually through Zoom. So we're talking about less than 2% of people who are having to call in because they have no other way. So that's a significant improvement over what we had before the pandemic, when people would just call in because Zoom didn't exist, right, in courts. We are better now than we were before in that way. And I want to strongly support something Judge Miskell said. And this is a big conversation, so we're not going to have it. But I'll tell you this. I am also a CPS judge. I'm general jurisdiction. Historically, in rural areas, it is almost impossible to get children at CPS hearings. Now, the code requires that the court see the child every hearing, talk to the child every hearing. But the reality is, where I am, we don't have foster homes. There were 0, by the way, until I went on a push to get some in each county, and now we have a couple. The children were placed in El Paso, in San Angelo, in San Antonio, and further. It takes 2 CPS workers to transport a child, right? Because they have to stay the night somewhere. And so they're not going to have a child staying the night with a CPS worker alone. So it takes 2 to do this process. Guess how many CPS workers I have in my district? 2. So my whole department would have to go get a child. Well, if I have a docket and I have 4 children placed in different towns, I can't see them. It is literally impossible because I don't have the manpower. Now I see them every single time. I see every child in every hearing. And if it's a baby, they hold the baby up and they turn the baby all around and everybody grins. And we're so thrilled to see this child. And there's a bruise here. And what's this over there? And how's the inoculation doing? We have such great involvement. The children who are in high school would have to miss 2 days of school to come tell me what they want. You know, we have to listen to these kids because bad things do happen to children. I know this comes as a shock. If we don't talk to the kids, we don't know what's going on because the foster family might not be willing to tell us what the child's willing to tell us. I just saw a hearing the other day where Judge Rob Hoffman interviewed a high schooler from, I think from the school, but certainly from his town far away from Judge Hoffman. And they came out of that with a new plan of action based on something that was said. It is crucial for high quality justice in child welfare cases that the judges interact with the children. And I'm telling you, this has revolutionized the interaction that I can have with children. And I know this is true across the board with child welfare judges across the state. So crucial issue. Thank you, Judge Miskell, for bringing that up, and Chief for letting me jump back in.
Well, thanks.
If I could just add, Judge, just
Yes,
really
ma'am.
quick, that we just echo what he said as well, but also just to thank OCA for all of their efforts. We would not have gotten as far as we could if it hadn't been for David Slayton. And it's just not about the technology, but just the encouragement that we've received has been invaluable. It's just been such a wonderful transition. We're doing this in only a year. I can't imagine what will be in the next year, but I hope it will be virtually just as amazing as the last.
Well, thanks to the three of you and to Judge Crump, what marvelous work you're doing and how much you contributed to really a reasoned and skilled process of moving forward. It's we really are determined to take what we learned in the pandemic and build on it. So thanks to all of you. Thank you for sharing your time with us today, and you're welcome to stay. We have a great presentation next, or you're of course welcome to depart. So thanks again. Next on the agenda is the fiscal year 20 statistical report, which will tell us how the pandemic has affected our dockets across the board. And here is our data analyst extraordinaire, Angela Garcia, to present it. Angela?
Yes, thank you very much, Chief. Good morning, members. I'll share my screen here.
Angela, if you're having issues, I can share it from this side if you want me to.
Great. Would you do that, please?
Yes, let me get it started here.
Thank you.
Okay, just tell me when you're ready to go next one. I'll do that.
So I'm going to make this quick because obviously with the pandemic, the main message is that filings have gone way down. So go ahead. Compared to last year, filings declined at all court levels, anywhere from 6% in the highest appellate courts to almost a quarter in the Justice and Municipal Court. But still, there were 7.3 million cases filed in the state. Okay. On the civil side, new civil case filings fell at every court level, from 13% in the district courts to 22% in the municipal courts. Filings declined in every single case category, with the smallest reductions in medical malpractice and JP debt claims. And JP debt claims are very important because there's still a ton of cases. Okay. Despite the declines in 2020, the number of debt cases filed still exceeded the number filed in 2018. Prior to the pandemic, debt cases accounted for nearly half of county court at law cases and justice court cases, as well as a fifth of district court and constitutional county court cases. So although there's been a decline, we're still at a very high level historically of debt cases. After reaching an all-time high in 2019, new landlord-tenant cases filed in justice courts fell 28% due to the pandemic, and the restrictions placed on filing of eviction cases beginning in March 2020. So we know that those are all going to go up. And in 2019, landlord-tenant cases represented 42% of the Justice Court's caseload. In contrast to the other steep declines in civil case categories, involuntary mental health commitments declined only very slightly in 2020. And the only area of growth in filings on the civil side were administration cases of estates, administration of estates, both independent and dependent, and adult guardianships. So probate really wasn't affected that much by the pandemic. On the family side, after reaching an all-time high in 2018, the number of family cases declined to the lowest level since 1998. The number of post-judgment suits also declined at a similar rate. New filings declined in all family case categories, but the most significant declines occurred in child support cases. Applications for protective order did not decline that as much, basically did not change at all, so that's concerning. I do want to mention that in 2019, child support cases had been on the decline, and that was due to the Attorney General's office of refocusing their efforts on actionable cases where they thought that they could actually move it and find the parties. New divorce cases not involving children continued at a similar decline that it's been over the last few years. Same thing with divorce with children. After 6 years of growth in CPS cases, filings were down in 7% in 2019 and by an equal percentage in 2020. And in 2019, that was a nationwide trend, and that was probably due to the Families First Act, where federal funds were allowed to be spent on helping families with mental health services, substance abuse treatment, and in-home parent skill-based. So it had been declined, but of course, everybody's worried that with the pandemic that these cases are hiding. Juvenile cases declined to new historic rates. Since 2017, it's fallen 60% to the lowest level since 1993. And for the first time, felony offenses outpaced misdemeanor offenses. So more serious cases being heard. On the juvenile side, homicides was the only category to increase in 2020. DWI remained changed. Felony and misdemeanor drug cases declined significantly. And again, felonies outpaced misdemeanors for the first time. Significant declines occurred in Class C cases in all case categories except for tobacco and e-cigarette. The big significant declines that you've seen in previous years were due to Judicial Council initiatives for school ticketing laws and truancy laws that have really tried to keep these children out of the criminal justice system. In 2020, about half of cases filed against juvenile or minors were traffic cases. The rest were non-traffic. On the criminal side, the number of new misdemeanor cases has been falling since 2007, but took a steep dive in 2020 due to the pandemic and a significant decline in drug cases. It's down 45% from the peak and was the lowest filing rate since at least 1985. The number of new felony cases filed is increased each year since 2014, reached an all-time high in 2019, and of course declined with the pandemic. The most significant declines in misdemeanor cases occurred in marijuana possession and driving with a license or driving a suspended or invalid license, while the more significant violent assaults increased. So family violence assault and assault increased while everything else went down. The steepest declines in felony cases occurred in drug cases and child cases involving indecency or sexual assault of a child. Aside from capital murder, aggravated offenses, family violence, and auto theft were the only categories that increased in 2020. New misdemeanor drug possession cases fell by almost half in 2020 due to the continued decline of the prosecution of marijuana cases, as well as an overall steep decrease in misdemeanor cases filed during the pandemic. After reaching a peak in 2019, felony drug possession cases also declined, but at a much slower rate, and exceeded the number of misdemeanor drug cases filed for the first time since 1994. So in all areas, we're seeing more significant, more serious juvenile and criminal cases being filed, if they're filed at all. Finally, misdemeanor cases declined significantly in 2020 and have been on a 12-year decline, especially for traffic and parking cases. The number filed in 2020 was 56% lower than the peak and was the lowest number filed since 1980. The number of non-traffic cases was the lowest filed since 1979. And the appellate courts, although criminal cases have been declining for years in the courts of appeals, they fell sharply in 2020 due to the pandemic. In 2019, there was the highest civil filing rate in history, but of course, the number of filings declined by 11% due to the pandemic in 2020. In the Court of Criminal Appeals, applications for writs of habeas corpus have declined to the lowest level since 2001, and petitions for discretionary review to the lowest level since 1989. There's been a significant decline or gradual decline in the Court of Criminal Appeals caseloads as trial court criminal caseloads have declined over the years. Finally, in the Supreme Court, after reaching the highest number filed since 2002, petitions for review decreased in 2020. And that makes up, sorry for the barking dog. And the number of cases added to the docket, those are those cases that are selected for review by the court, increased by 18%. And David also had me look at more recent statistics to see how the pandemic is really affecting pending caseloads. So although there were significant declines in filings in 2020, the pandemic created a lot of challenges, as we discussed, for courts in processing their cases. But despite those challenges, courts in at least 4 court levels exceeded 100% in their case clearance rates, meaning that they were disposing of more cases than were coming in. But still, 7.4 million cases were disposed during the fiscal year. Now, looking at the period of March 2020 to January 31st, which is the best data available, lower clearance rates in district courts and county courts at law have led to a 9% increase in active pending cases in the district courts, which is almost 82,000 cases of backlog. And the criminal backlog in particular grew 34%. Reduced criminal and family law case clearance rates have also resulted in 11% increase in the backlog at county courts at law, more than 57,000 cases. And the criminal case backlog in particular grew 25%. From March to January of this year, case clearance rates in felony, misdemeanor, family, and municipal civil cases have been especially low. And statewide, if you look at the change in active pending caseload for district and county courts, go ahead, David. The felony backlog has grown 26% to almost 49,000 cases, misdemeanor by 19%, almost 62 or more than 62,000 cases, and family by 9%. So more than 34,000 cases for a total of more than 136,000 cases added to the pending backlog at the end of January. And that's all I had. If you have any questions, I'd be happy to answer.
Questions of Angela? Well, a lot of this is what we expected, but we have been visiting with the legislature about the possibility, the likelihood of a significant backlog and what we're going to do about it, how we plan to reduce it. And the Supreme Court's asked for funding for visiting judges, but we've got 2 or 3 other plans that we're working on to try to make sure that as we can, we get on top of this so that we don't feel the impact of the pandemic any longer than we have to. But it's we're trying to stay abreast of the statistics. Thanks, Angela. Next on the agenda is a report on the Protective Order Registry and Citation by Publication database, which OCA has been instructed to create, and despite the pandemic, they've done that. So let's see, Kim Pichoyak and Brandon Bellis are going to present.
Thank you, Chief. Good morning, everybody. I'm Kimberly Pichoyak. I'm a domestic violence training attorney. I'm going to talk briefly about the Protective Order Registry before I pass it off to my colleague, Brandon, to talk about citation by publication. I'm going to go ahead and share my screen. All right, can y'all see it? Very good. All right, well, the Protective Order Registry lives in the Texas Government Code in Chapter 72, and it actually was established by in last session by Senate Bill 325 and House Bill 629, and it's named for this young lady, Monica Deming. Monica Deming was killed by her ex-boyfriend about 3 days after this photograph was taken. After her death, it became known that the ex-boyfriend actually had been the subject of not one, but two prior protective orders involving two former partners before he had even met Monica. So for our schedule, we actually went live, became operational on September 1st. At that time, we were able to grant access and training we had a few pilot courts that were able to get in and enter orders and kind of test it and help us troubleshoot so we can make sure that we're making it as user-friendly and helpful for everybody else. And so we did that. At the same time, I was creating different webinars based upon different courts, the types of orders that they have and the types of information that they would need in order to utilize the registry. And so actual mandatory entry started on October the 15th, and that was for all filed applications and issued protective orders that were filed or issued on October the 15th or after. And that entry is required to occur per statute within 24 hours after the filing or the issuance of the order. So what we were doing during that same time and since was we made sure that the public access feature was enabled, and those are again for final protective orders only. And that is also only with the written consent of the protected party. And so, but that is, again, it's only for very limited information about that final protective order. It's not copies of the actual signed order themselves. If someone wants that, they still need to take themselves to the courthouse and request that. We also were able to grant access and provide instructions on system use to our restricted users. Our restricted users are the folks in law enforcement and prosecutors' offices. They cannot do any entry into the system, but they get to see everything that's in the system. And we were able to get that started right at the end of the year and got everybody going with access in early February. And so now what we're doing, I'm creating training for law enforcement and prosecutors. I'm actually hoping to have something available that we can do and send out for do webinars so that they can get credits, CLE credits, and also team credits for law enforcement. I also I'm looking to do one for our judges, even though judges aren't getting in and entering or anything like that. I definitely want to see what we can do to help streamline what they need on their end to make sure that these are getting entered into the system. Conducting training and disseminating awareness information to advocacy groups. I've already done a little bit of this, and I'm going to continue doing that. We do still need to update the Supreme Court Protective Order Kit with the information. And also, I will be performing outreach to counties and courts that are not yet utilizing the registry. I've got a report that I check on every now and then, and I'm able to see who hasn't entered what counties haven't entered any orders whatsoever. And of course, from the beginning of all of this, we've been able to provide system access, technical assistance, and training for all interested users. Training was a big component of this as well. And also we have continual adaptation of the system for evolving needs. I work really closely with our design team. And whenever we hear from our users that there's a problem or that there is something that maybe we didn't anticipate, we've been able to have a pretty good direct connection with those folks so that they can help us do the tweaking as we need as we go along. The registry itself, the basic website where everything is actually through, or at least the information is through our website, texascourts.gov. The actual place where clerks and courts enter protective orders is through the portal. And this website, portal.txcourts.gov, that is also the same place where courts enter the citation by publication information as well. So they go to one place if they need to do any data entry. Then we also have the public access. The public access is through our topics website, Texas Online Public Information -courts. And again, this is the same place where the public can go to look at any information that may be there for protective orders, but also can go and check those citations that are published there in addition to whatever may be in the newspaper or local publication. And then the most recent door that has been added to this house that is the Protective Order Registry is the Protective Order Registry of Texas. It's called Protect, and that is our law enforcement access and prosecutor access. We wanted to make it different and separate because obviously the goals for those users are a little bit different than the courts and also for the public. Also, it's a little less hackable when it's on a website that I don't publish to the world. I let courts know about it, that it's there. So if they have inquiries from law enforcement, that they can certainly direct them to us and we will get them set up into the system. But those are the three doors of how to get access depending on what type of user you are. By the numbers, I ran these on Wednesday. As of Wednesday, we had just over 24,000 entries into the Protective Order Registry, and that includes applications. There are some entries that are just an application. There are other entries that are applications and orders. It just kind of depends on the particular situation. We have over 18,000 magistrates' orders of emergency protection. 3,500, just over 3,500 temporary ex parte protective orders, those interim orders that happen between the time when someone applies for a final protective order and they actually have the hearing on that final order. And there are just over 2,400 final or permanent protective orders that basically are done after a hearing is held. At this time, there are only 18 publicly accessible protective order records. So there's 18 cases, 18 instances where the protected party has requested specifically that this limited information does go onto the public site. As far as training, again, training has been a big component as part of the mandate. I have participated in 36 training events, many of which we did really early on, several we did early on every Friday of the world for all of our court users so they could get all the information they needed to get started. During those 36 events, I had 2,925 attendees, folks that have been trained on the registry. As of right now, the number of counties that have entered orders for magistrates' orders of emergency protection, there's been 159. And for temporary ex parte orders and final protective orders, there's 162 counties. So we're running at about 92, 95 counties who have none entered just yet. So my goal here coming up is to start reaching out individually to those counties, offering a technical assistance and training and see what it is that they need to get done to be able to get started. So at this point, I'm going to go ahead and pass it over to my colleague, Brandon, and I'm going to go ahead and run the PowerPoint if that's okay. So Brandon, you're up next.
All right, thanks, Kim. Good morning, everyone. I just wanted to give you a quick update on our citation by publication database. As Kim noted, we had a set of bills that came out of the 86 legislature that mandated these systems. The citation by publication database is one of those. Can be found in Government Code 72.034. The system launched on July 1st. We were able to get it up and running during the pandemic, which was no small feat, and a lot of thanks to the IT team that worked to do that. It was not an easy thing on the schedule they had. So much like the protective order database, we have a public facing side and an internal side for clerks and court staff to use. So follows very much the same footprint. The public accesses the system through topics, basic searches of public citations and notices, and then clerks and court staff enter through the portal. In general, OCA does not review or edit submissions. So these are done, uploaded by the clerks and court staff. There's a small wrinkle to that, which I'll get into in a minute, for certain federal court cases, which to our surprise, we were getting requests for those. So let's go ahead and go to the next page. So in terms of under the hood and what's going on, we have just over 2,300 unique users of publication rights. Interestingly, though, we have a much smaller segment of those people who are actually publishing or editing publications. When we built the system, it granted access automatically to everyone that we uploaded, and we tried to grab everyone. So there are people in there who have not used it, and you'll see that down here a little bit further. We have 77 counties that actually have not entered a single entry into the system. And I did a little bit more digging on that. Of those, all of those counties are below 45,000 in population, and only 6 of them are above 20. So there are small counties. So might be some work there to do to reach out to make sure that everyone knows that it's there. Total citations as of Monday was just short of 10,500, and that included 3 federal citations. So we learned that Federal Rule of Civil Procedure 4E1 permitted service through this system. So we were able to set up essentially a dummy account inside, and when we get those requests, we take care of them ourselves. The most frequent citation type, and I bring this up because as we learn about modifications we can make, we built one that was built to be flexible, that gave the clerks the ability to pick any date. Most were set for specific end dates on publications, and would then send out a notice or a return. We wanted to give clerks the ability to have some flexibility, and they've leaned into it. And it's about 90% of the entries are being manually inserted that way. So it may affect the way we do some toggling with the system going forward, but for now, that's the way it's being used. On the next slide, we have just our general, I wanted to do a top 10 by entries, just so that folks could see where things were taking place. I don't think anything too surprising here. And in general, probate court users do dominate most entries. And then on the last slide, if you can move over to that one, Kim. So this was our yearly flow in terms of entries. About what we would expect, I think, in terms of seasonal use. You do see a decline there in November. And then you'll notice that one of these things is not like the others. And we had a spike in usage through March, which I think can likely be attributed to the winter storm, to show you just how far the disruption is. We can see it everywhere. In terms of future plans, we're hoping to do an automated piece on the return release. As of now, when we attempted to get the system out, we didn't go for the bells and whistles, just wanted to get it out there working. We have to manually release returns, and that means somebody logs in every day and punches a button and lets them go. So the hope is that we'll be able to do that automatically here soon. And then some document upload capacity in terms of what's being done. Right now, there's a lot of manual entry, which can lead to some error, and we don't want that happening. So the ability to put in copy and paste documents or upload PDFs and that sort of deal. But that concludes my presentation. We'd be happy to take any questions if we have them.
Thanks, Kim and Brandon. Any questions for them on these 2 projects?
Can I just add one thing to Brandon's presentation, just for everybody's benefit that might be unfamiliar with citation by publication before this? Before this bill passed, the way that citation by publication happened was that it was published in a newspaper of general circulation in the county. And part of the legislative reasoning for passing this bill was the tremendous cost and the lack of real notice that there was concerns about. And so basically this for people, there is still a requirement that it be in the newspaper in certain situations. But for people who can't afford that cost, which can sometimes be in the thousands of dollars, there's not a requirement to publish on the newspaper, or if there's not a newspaper of general circulation, which some counties didn't have. So it seems to be going very well. And there are other bills to actually replicate it for other types of notices this session.
That's great. Well, thanks very much. And thank you for your hard work in difficult circumstances to get those going. We'll turn now to e-filing, the contract renewal, and the uniform case management system. I'll just tell you a brief story that right after the pandemic hit, right, March 13 is when the emergency was declared. A few days after that, the next week, I was talking to Chief Judge Janet E. Fiore in New York about the situation up there. And she said, well, we've had to completely shut down the courthouses and nothing's happening. And I said, well, don't you just keep getting filings in and surely you can work on those from home? No, they don't have electronic filing in most of New York. And so all filings are paper. And if you remember back then, there was a concern the virus could be transmitted on paper. So a lot of stores would not take cash because they didn't want anybody handling paper. And that was true of the courts in New York. So you could mail it in, or you could go by the courthouse and dump it in a box. But then an employee would come out eventually and radiate all that paper to make sure it wasn't going to kill the clerk when they tried to put it in a file. So Texas has not had that problem since we've mandated e-filing. We've been able to get through that part of Harvey and the pandemic without having to worry much about it. But we need to re-up it, and we need to work on case management systems, and Casey Kennedy will report on how we're doing.
Thank you, Chief. Good morning, everybody, and I'll be very quick and brief. Since our last meeting, we have taken the e-file contract out for renewal, and through the bidding process, OCA has awarded that contract again to Tyler Technologies, and that will give us e-filing through August of 2027. With that, we do get a lot of good enhancements. We'll be moving to the current version of the electronic filing standard, which is ECF 5. They're actually moving our system from Microsoft Azure One cloud platform over to Amazon AWS, which will give us a little bit more flexibility and elasticity so that the system can expand. Currently today in our current system, we've got almost 450,000 users, and they're filing about 39,000 envelopes each day, every day during the week. So it's getting hammered all the time. Some of the other things that we'll be adding in, reworking some of the return for correction process. That's working well, but then there's things that we can do to improve upon that. Same with proposed orders. We're working proposed orders through the filing system today, and it's kind of been put there, but we'll be working to make that much more efficient too. We'll be doing this in kind of a phased approach, and so throughout the next, I think, up through 2023, we'll be doing different kinds of things to the existing e-filing system to bring it up to the next generation of e-filing. Coming up in phase one, the first thing is we'll be replacing the clerk review tool. It's using some outdated technology that is reaching end of life. And so we'll be doing that. This will also give the clerks the ability to do some kind of bulk reviews where they get lots of filings in at once. Instead of clicking on them one at a time, they can say, these are all good, bring them all in. In phase two, there'll be more clerk enhancements, a lot of enhancements for our filers on the state filing service provider. Lots of security enhancements. You'll see the return for correction work in that. In phase 3, bulk stuff continues. We'll start allowing bulk e-filing from attorneys. One of the other feedback pieces that we'll be adding is multi-firmed attorneys. Right now, when an attorney files an e-filing, they're just part of a single law firm, which is problematic if you have attorneys that do pro bono work in the evening and then work for a large law firm during the daytime. They want to be able to separate those two attorney hats so that their filings are going depending on where they're going. They'll be able to do that. And then on phase 4, we'll be doing a lot more enhancements to it to give the trial court clerks more control over the system for their jurisdiction. Right now, there's a lot of things that the clerks want to change or do that results in a ticket into the e-filing vendor for them to do. And so in phase 4, there'll be a tool for them that will allow them to go in and make those changes themselves without having to get Tyler Tech involved. One of the biggest things that I'm excited about, and I'm sure Angela and David are probably, and Megan too, are excited about, is in phase 1, they are introducing e-filing insights, which Tyler recently brought a business intelligence tool called Socrata. And so they'll be layering that on top of all the e-filing data that's coming in so that in near real time, David and Angela can go in and look at what's going on with the e-filing systems, how are cases going in this jurisdiction, and they can see that in near real time. And we'll make that available to the local clerks as well so that they can see what's going on with filings in their area as well. So things are moving fast. The last thing that I'll talk about, we're working on our presentation. We'll be getting with the Clerks Association to bring them in, and with our case management vendors and our other service providers to bring them in the loop as we finalize the schedule for each of these phases and what goes where. On our UCMS project, that's our Uniform Case Management System. This was a budget item that's from the current biennium. And what it does is it directs OCA to go out and procure a uniform case management system for counties of 20,000 or less. It's important to know that this system is designed as part of its requirements to be fully integrated. So integrated with e-filing, integrated with Research Texas so that transaction happens in real time. And then also integrated with DPS, because we're finding some of the smaller counties are having to key in information to DPS that is required. And so this system would allow them to do what some of our larger counties do, to where that file just goes over every day. And then obviously some of the OCA monthly reporting. OCA does envision this system to be opt-in, so this isn't required by the clerks at the smaller counties, but it's just another option that they can do if they choose. Where we are with it is we put the RFO for it out back last Thanksgiving, or right about Thanksgiving. The responses came in, and we're still in the stage where our evaluation committee is evaluating all the responses. From there, the evaluation committee will recommend to OCA which vendor or vendors we should negotiate with, and we expect to have our contract signed about at the beginning of late May, beginning of June, so that we can continue on and push that project ahead. And so that's my very brief update, Chief.
Thanks, Casey. Making good progress there. Any questions of Casey? You know, sometimes we hear these things and we underestimate the work that's been involved in them. For years and years, we wanted to have e-filing and case management, but the state was just so big and diverse, nobody thought it was possible. And it really is remarkable in a state like ours, where you got Judge Ferguson's district, which is bigger than 9 states. And then you've got very different districts around the state to try to get this working well. So we're very glad of all that good work. Last on the agenda is a legislative update from Megan Lavoie. And today is Megan's birthday. So wish Megan happy birthday.
Well, thank you, Chief. I wouldn't want to spend it anywhere else. I'm going to provide a brief legislative update for y'all this morning. We have 51 days left in the legislative session. A legislative staffer created this neat little countdown that I wanted to include in this presentation, which Kelly is going to share for us. Thank you. I couldn't get it to work, so I think I'm gonna have to ask Judge Ferguson for technical assistance in the future, because his little picture-in-picture in his presentation was really neat. I hadn't seen that before. 51 days seems like a long time, but it will go very fast. And Kelly, if you'll move to the next slide. It feels like the session has shifted into full gear over the last 3 weeks after a slow start due to COVID-19 and Winter Storm Uri. You can see that the bill filings are slightly down from the 86th legislative session. I have some other interesting statistics for you. The Office of Court Administration completes more fiscal notes and bill analyses than any other agency in the state, with the exception of the comptroller. This session, we have been assigned 1,166 fiscal notes. Any bill that mentions courts, liability, criminal penalties, civil law changes, or even new water districts, we get a request to do a fiscal note. Last weekend, we had more than 100 due, which made for a busy and interesting Easter weekend. You go to the next slide. I'm going to go through each of the council's committees and their recommendations to show you what bills coincide with each recommendation, starting with the council's Criminal Justice Committee. As you remember, the council has made recommendations since 2017 to modernize our state's pretrial system. The council's recommendations are in House Bill 20 by Representative Murr and HJR 4 by Representative Casal. The legislation is named after Damon Allen, a state trooper that was shot by an individual out on bail back in November of 2017. The bail legislation was heard in the House Criminal Jurisprudence Committee this past Tuesday. The hearing went all night, and when I say all night, I really mean it. House Bill 20's hearing began just after 1 a.m. and wrapped up at 4 a.m. The legislation includes all of the council's bail recommendations, including requiring judges to use a validated pretrial risk assessment, allowing for preventative detention for high risk and potentially violent defendants, and increased training for magistrates and new data collection requirements for OCA. The hearing on Tuesday was actually different from the hearings that have occurred during the last 2 legislative sessions. The testimony was more positive and pro-bail reform than years past. We've been working diligently with the authors, Committee Chair Collier, the governor, and many other stakeholders on House Bill 20 and HJR 4. We've also been working with Senator Huffman on Senate Bill 21, which is the Senate's bail reform bill. We're hopeful that both chambers can come to some kind of consensus, and we will finally have movement on this issue that we've been working on for the past several sessions. Another carryover from last session is the council's youth class C diversion legislation. If you recall, the bill passed the House last session, but made it over to the Senate too late in the process for a hearing. The bills this session are authored by Representative White and Senator Perry. They would allow youth charged with Class C fine-only offenses to be handled similarly to the way more serious offenses are handled in the juvenile justice system. Right now, if you're a juvenile and charged with a Class A or B misdemeanor or felony, your case is treated as a civil case. But if you're charged with a Class C misdemeanor like trespassing, you're charged as a criminal. Texas is one of only 2 states that handle juvenile Class C misdemeanors in this manner. The bills would require diversion strategies to be used like teen court programs, alcohol awareness and drug programs, and work or education training. Senate Bill 512 was heard in the Senate Criminal Justice Committee actually yesterday, and it was left pending in committee while some cleanup is done in committee substitute. And the bill will be heard on Monday in House Juvenile Justice and Family Issues Committee. The council adopted the recommendations from the Judicial Commission on Mental Health. The recommendations are included in 2 bills. The first is Senate Bill 1739 by Senator Zaffirini and its companion House Bill 4212 by Representative Moody. We call these the mental health omnibus bills because they contain 11 of the Commission's recommendations. The legislation includes clarification of time periods for competency, orders, and acceptance of pleas in justice and municipal courts. Many of the provisions are changes to improve practical implementation problems observed by the members of the Mental Health Commission's Legislative Committee, who are experts in the field. House Bill 4212 was heard in the House Corrections Committee on Wednesday this week. Justice Bland and Justice Boyce testified as resources on the bill, and it was well received. Senate Bill 1511 by Senator Zaffarine and House Bill 3977 by Representative Moody contain the Commission's recommendations related to emergency detention procedures. The bills have been referred to Senate State Affairs and House Public Health. Moving on to legislative recommendations from the Public Trust and Confidence Committee, Senate Bill 690 by Senator Zaffarini and House Bill 3611 by Representative Leach were filed to remove any statutory barriers to continuing remote proceedings after the state's COVID-19 disaster and Supreme Court emergency order expire. We've already heard from Judge Ferguson, Judge Miskell, Judge Crump, and Judge Arteaga on the success and challenges of remote hearings over the past year. I will say that we have had stakeholder sessions with a variety of groups, including prosecutors, defense attorneys, the Family Law Foundation, Access to Justice, and many more concerning this legislation. We're hopeful we can come to a consensus soon. The main sticking point seems to be that some of the stakeholders want consent of the parties to move forward with a remote proceeding. Senate Bill 1740 by Senator Zaffarini has the committee's recommendations related to civic education. The bill requires social study teachers to receive additional civics training, and it requires curriculum for students to include understanding of qualities, traditions, and features of civic engagement and processes of government institutions at the federal, state, and local levels. The bill has been referred to the Senate Committee on Education. Moving on to recommendations from the Civil Justice Committee, Senate Bill 644 by Senator Zaffarini and House Bill 3613 by Representative Leach contain the council's recommendations for a basic needs exemption. The economic hardship caused by the pandemic and Winter Storm Uri has made modernizing wage garnishment and seizure laws to protect wages earned by Texas workers very important. The bill would provide a basic needs exemption to allow people to meet basic needs while repaying old debts and create an easy to navigate process for people to challenge wrongful seizure of exempt funds. The Texas Access to Justice Commission and other stakeholders have been working on a solution that would include a minimum amount of funds that would be protected from seizure to pay for basic needs like rent, food, utilities, as well as procedures for enhanced notice. The bills are in the House Judiciary and Civil Jurisprudence Committee and Senate Jurisprudence Committees. The Council's recommendations to modernize the civil filing system, similar to the changes to criminal court costs last session, are included in Senate Bill 41 by Senator Zaffarini and House Bill 4417 by Representative Moody. There are several bills that contain some of the concepts from the council's previous recommendations to the 86th legislature that have been filed. Those include guardianship bills by Senator Zaffarini and Representative Murr to create specialized courts similar to our child protection courts to hear guardianship cases. If you remember, last session, legislation made it through the process, but was vetoed by the governor. House Bill 79 was voted out of the Judiciary and Civil Jurisprudence Committee 9-0 and is actually set on the House calendar for discussion on Monday. In addition, Senate Bill 960 by Senator Zaffarini would create a pilot program to establish public guardians similar to the council's recommendations to have a statewide guardianship of last resort program. The bill has been referred to the Senate Jurisprudence Committee. House Bill 1875 by Representative Landgraf would establish a business court and business court of appeals. The courts would have civil jurisdiction concurrent with district courts and derivative actions on behalf of an organization and actions in which the amount in controversy exceeds 10 million. The bill was heard in the House Judiciary and Civil Jurisprudence Committee this past Tuesday. Our own Evan Young testified in committee and did a great job of answering members' questions on that bill. Moving on to case level data, as you know, every single council committee has recommended that the council move forward in collecting case level data. There have been several bills filed this session that would require the council to start collecting case level data much sooner. House Bill 3334 by Representative Turner creates a sentencing database with case level data, including race, age, and plea bargain information. That bill was heard along with House Bill 1930 by Representative Wally on Tuesday in the House Judiciary and Civil Jurisprudence Committee. Representative Wally's bill requires case level data on evictions. House Bill 4335 by Representative Ordaz Perez has been referred also to the House Judiciary Committee. On House Bill 3334, OCA put a fiscal note of $3.8 million to build the sentencing database and the data warehouse to collect the case level data, as well as ongoing costs for cloud storage and maintenance. Other bills of interest, Senate Bill 11 would reorganize the courts of appeals from 14 courts to 7 courts. The bill passed the Senate Jurisprudence Committee after a lengthy hearing where several appellate justices testified. And we got late breaking news last night after I had made this presentation. Senator Huffman wrote a letter to senators last night saying, since the 87th legislature concludes its business at the end of May, time does not allow for Senate Bill 11 to move further in the legislative process this session. So that bill is not moving forward at this time. Senate Bill 1529, this bill creates, also by Senator Huffman, creates the Texas Court of Appeals, a statewide court of appeals that has exclusive appellate jurisdiction over all cases or any matters arising out of or related to a civil case brought by or against a state or state agency, board, or commission, or by or against an officer of the state or a state agency, board, or commission. The court would have 5 justices and be elected in November 2022, with the court creation date being January 1st, 2023. The bill passed out of the Senate Jurisprudence Committee 3-2 along party lines. It is on the Senate intent calendar. We had expected it to be taken up yesterday, but it wasn't, but it can be taken up anytime. House Bill 3774 is the court omnibus bill. It's a tradition every session for the chairs of Senate and House committees that have jurisdiction over the judiciary to author a court's omnibus bill to create new courts, make changes to judicial boundaries, and changes to jurisdiction and judicial administration. House Bill 3774 was heard in House Judiciary and Civil Jurisprudence on Tuesday this week, and we are awaiting a committee substitute. That bill is going to have a lot in it, so stay tuned on that one. All right, moving forward to some highlights from the budget. The Senate heard the budget on the floor on Tuesday, and it received a unanimous vote 31-0. The House has adopted its budget recommendations, but that hasn't made its way to the floor just yet. The introduced bills in both chambers restored the 5% cuts to the Supreme Court, Court of Criminal Appeals, and appellate courts. State agencies and entities were required to make a 5% reduction last summer in anticipation of a budget shortfall, mainly due to the pandemic. The committee substitute for Senate Bill 1 provides $919 million for the judiciary, which is 0.4% of the entire state budget. The cuts to OCA's guardianship, abuse, fraud, and exploitation deterrence program were restored. And for the most part, funding remains at current 2020-21 levels for most programs in the judiciary. The House adopted an additional $4 million for legal aid. It restored $300,000 in travel cuts to our child protection and child support courts and $4.5 million in cuts to TIDC. A big theme throughout both budgets is the unknowns related to federal funding. The state expects to receive upwards of $12 billion in federal funding, and we expect budget changes to be made when more information is available on those funding streams. The House adopted in Article 11, which is the legislature's wish list, the judiciary's request for an additional $6.8 million for additional visiting judges to assist with COVID-19 backlogs that we discussed a little bit earlier. And that's my brief update. If you have any questions, I'm happy to answer them.
Thanks, Megan. Any questions for Megan on her report?
Chief, this is Judge Gravel. I'd like to make a comment. If I could. Sure. Megan brought it up, but I think it matters to the whole conversation. County judge, my judges during the pandemic, every new technology development.
We're having trouble hearing you, Judge.
Can you hear me now, Chief?
Yes.
I was just saying our judges have made requests from Commissioners Court, and we've provided all of the technology pieces needed. But now we have an additional $115 million coming from the Americans Rescue Act. And that's another funding resource, I believe, to help with the backlog in cases. And I just wanted to remind Megan that not only does the state have several, Williamson County and all of its cities will receive another $2 million. So don't just look for legislative fixes. Realize that there are tools in the local community as a result of that.
Yeah, I think I know Judge Gravel is cutting out, but he's talking about different federal funds that are coming in, and there are going to be federal funds coming into the state, but also coming into local governments. And he was mentioning that we, if you couldn't hear that, we need to keep an eye on those funding sources to perhaps fund some of our technology or other infrastructure requests. And we are watching that. And I know that the National Center for State Courts is also keeping an eye on those federal dollars and to help alert judiciaries across the country if we have access to them.
Any other questions or comments? I'll tell you that Megan and David are working very hard on this, just almost around the clock. David and I were going to go testify on House Bill 20 regards bail reform this week, and committee hearing started at 4:21 in the afternoon, and when they finally called David to testify about a little after 3:30 in the morning, I wasn't there. So one of us testifies before 9 o'clock in the evening, and the other one after midnight. So it was David carrying the ball for us. And I got a text from him at 4:01 a.m. saying it was over with. So everybody's working very hard on this, but I hope you can see that these resolutions that the council adopts and these initiatives that we recommend then actually do translate into legislation, and then people supporting it and drawing all kinds of support beyond just the council, and making a big difference in the state judiciary. So thanks everybody for the hard work on committees, coming up with the resolutions and drafting legislation, and now seeing it pass. And we thank our members, Senator Zaffarini and Representative Murr and others for their work in carrying our bills. Chairman Leach has been especially helpful. Chairman Huffman, I don't want to start naming everybody, I'll forget somebody, but lots of good help for the judiciary in the either the first branch or second branch of government, depends on who you ask. So that's our agenda for today. Any other business for the good of the order? Yes, Judge.
Chief, yeah, I was just wondering if we're going to be expecting from the Justice Court level any more clarification on our evictions. I could talk to David offline, but I've been asked that a million times, and so we're always kind of looking at our emails trying to figure out if something else is coming down the pipe.
I can't tell you for sure, but we're aware of it. We just got some comments from the legal aid lawyers yesterday afternoon, and of course the training center made a presentation last Friday. So we're continuing to take a look at it and trying to sort through it, Judge. I know the judges are looking for direction, and we're going to try to provide as much as we can. And it's a big issue all over the country. The Associate Attorney General of the United States called yesterday morning and was visiting about the same issue as it affects state courts around the country. So it's a developing issue, but.
John
Anything
Gimble
else?
had it. John Gimble had his hand up.
Oh, John.
Yes, sir. One of the things in planning, we're going to reopen jury trials on May 3rd, and space is our biggest consideration. Is there any thought? I know the CDC had moved for educational purposes to go down to 3 foot of social distancing. That would allow us to use our existing courtrooms once we get through with voir dire. Is that something under consideration?
David?
Good question, John. We're actually at the national level working on this. We have the same question, which is if it's, obviously there's different risk levels for children, school children, than there are for adults. And so we're trying to figure out from them any guidance they can give us to update what the appropriate recommendations are. So we'll get that out to you as soon as we can, but there's definitely a national effort to try to get clarification from the CDC on that and whether or not there's any changes we can make. What you've mentioned, I know the council members probably know this, but what you've mentioned is a huge concern, a huge issue for many jurisdictions who just have difficulty with space. None of our courthouses were built for social distancing. They're built quite the opposite, actually. Yeah, we'll try to get you an update as quickly as we can on that.
And we're hoping that there may be some movement on you can wear masks or socially distance, but maybe not have to do both. And there might be some moderation on that. So we're hoping that we'll see some movement on that. There's a lot of pressure building on more jury trials. So more trials generally. I don't mean to take away from the remote trials, but as you can see from the statistics, the lack of trials is really stacking up on us. Anything else? We don't have a meeting scheduled yet, but we will work on a schedule and probably be in late enough that maybe we can meet in person next time. So we'll look forward to that. Thanks everybody for coming today, but if there's no further business, the Judicial Council will stand adjourned. Thank you.
Thank you.